Is for Scott. Scott, we received a question from a member about their ability to fly a drone for commercial purposes, especially near an airport. Can you talk about the laws that apply to this situation?
Sure. Is this working, guys? Can you hear me okay? All right, perfect. Well, let's, I guess, first agree that it's generally not a good idea to fly anything near an airport other than an airplane without government permission. So we'll talk about the airport issue in a minute, but you need to know that the law has evolved over time, and specifically it was in June of 2016 that the FAA came out with a new rule, which is the small unmanned aircraft rule that applies to all unmanned aircraft drones that are 55 pounds and under. The best thing about this is you previously needed something that was called a Section 333 exemption. The problem with that exemption is in order to get it, you had to actually have a pilot's license. Not a lot of people have a pilot's license, so it was really hard to fly a drone. Do we have one? Do we have one with a pilot's license? Very nice. But you had to have a pilot's license in order to be able to fly the drones for commercial purposes. So there was a lot of lobbying, including actually NAR did a lot of lobbying with the FAA to get that rule changed, and it was changed. So the pilot's license is no longer required. You're no longer required to log a flight plan either. So both of those things were difficult. So now what you need to do is you need to obtain something that's called a remote pilot certificate. It is a lot easier to obtain. Once you get that, you have the authority to fly drones for commercial purposes. But there are some common sense restrictions in place. For example, you can't fly, you're not permitted to fly the drone out of your site. So if you're operating a drone, it can't be at such a far distance that you can no longer see it. You can't operate the drone at night. You can't go higher than 400 feet. You can't go faster than 100 miles an hour. You get the idea. So there are regulations in place, but overall, it's a much easier process than it once was. Okay, so it's to the airport portion of it. Yeah, again, common sense says you shouldn't be flying things around airports without permission from the FAA. So you can fly drones within restricted airspace. It's called controlled airspace. And the controlled airspace around airports, it's typically a 5-mile radius. Some airports have a larger one. If you go to Reagan National in DC, for example, it's a 30-mile radius. But typically it's a 5-mile radius. And if you're going to fly a drone near an airport within that 5-mile radius, you have to go to FAA's website. They have an FAA website. It's called their Drone Zone website. You submit, ask for permission. They'll come back, grant you permission, and it's only with their advance consent that you can go ahead and fly that drone near airports. But I think that's essentially a summary of the current law.
Okay, thank you for that, Scott. Michelle, a member submitted the following question. I read that the Consumer Financial Protection Bureau plans on enforcing some new rules about the ways that commissions are charged to the seller. For example, buyer not paying. Also that because of this, in the next 18 months, there will be changes made and the buyer will be sharing in the commission fees. Is this a factual issue? If so, is Arizona Association of Realtors and the National Association of Realtors working on this?
Thanks for the question. I don't know if I'm on. The consumer, the CFPB was very active in the Obama administration. So 6 or 7 years ago, you all know that the Consumer Financial Protection Bureau implemented and promulgated a lot of regulations that required a lot of rule changes. Scott worked a lot on those, on the forms changes, so that we made sure that our members were in compliance. With the change of administration from President Obama to President Trump, the Consumer Financial Protection Bureau, the regulations have loosened or lessened, and that continues to be the case. So in answer to the question from the member, no, to our knowledge, the Consumer Financial Protection Bureau is not advocating or promulgating any rules that would affect the way that real estate commissions are paid, who pays them, or how they are paid. So that part of it, I believe, as far as we are aware, is false. However, what the question may discussion may have arisen from the lawsuit that was filed against the National Association of Realtors and several large brokerage franchises. In that lawsuit that was filed a few months ago, and then followed by a couple of other quote-unquote copycat lawsuits that came after that, are class action lawsuits. And what those lawsuits allege is that sellers unfairly pay buyer brokers commissions, and that the lawsuits actually even challenge the value of a buyer's broker in a real estate transaction, and they are alleging an antitrust violation in our commission structure and the way our real estate industry works. They're really challenging the entire way the real estate industry works, and that's why they're targeting the National Association of Realtors, some large brokerages, and name a variety of other state and local associations and multiple listing services as unnamed quote-unquote co-conspirators in this vast conspiracy to fix real estate commissions. So that may be where the question arises. What is the National Association of Realtors doing about this? Obviously, we adamantly, in the National Association of Realtors, adamantly denies the allegations that are contained in this complaint. They are working. They have filed a motion to dismiss. Once they filed a motion to dismiss, because the plaintiff's attorneys even quoted the National Association of Realtors policies incorrectly in this complaint. Once they pointed that out to the plaintiff's attorneys, they immediately decided, well, we better amend our complaint. So they are amending the complaint. A motion to dismiss has been filed. They will try to consolidate all these cases. And if the motion to dismiss fails, and quite honestly, and these two gentlemen can probably attest to this, most motions to dismiss fail. They don't, but you file them, you never know, but most of them fail. So assuming that they consolidate the cases, the motion to dismiss fails, then they have to certify, the case has to be certified as a class action. And they're asking for billions of dollars, by the way. I mean, this is heavy allegations. Then the litigation and discovery process will proceed. I don't believe that we will see any decision out of this case for years. But what is important for you to know and for you to communicate when you talk to your clients, when you talk to anyone, is number one, the value that the realtors bring to a transaction, the value that a buyer's broker brings to the transaction. And that the fact that the multiple listing service and the system that we have is pro-competitive and pro-consumer. And those are important messages that our clients and our industry needs to get out. So we will continue to watch the litigation. It's been being actively defended by the National Association of Realtors and those involved, and we are actively monitoring the situation.
Now, I would just add one thing, and correct me if I'm wrong, but the Arizona Association of Realtors is not named as a defendant in that lawsuit. There's no local association in the state of Arizona that's been named as a defendant in that lawsuit. So yes, it may have an effect on our industry as a whole, but I did just want to make that clear.
Okay, thank you both for that. Rick, I understand that you're seeing lawsuits based on misrepresentations as to whether the property is connected to sewer, septic, or both, and that these claims are being more frequent. How do agents protect themselves, and how should we counsel our buyers and sellers regarding this issue?
Thank you, and I love the transition from national lawsuits to septic tanks. based on sewer septic issues, and I just kind of want to run through the scenario, and I think Prescott Valley have the same thing. If you get water service, you typically have a sewer charge on your water bill. A lot of people assume, therefore, they are connected to the sewer. They therefore tell their listing agent, yes, we're connected to sewer. They put in the SPDS, we're connected to sewer. And oftentimes, shortly after the close of escrow, the new buyer discovers, well, it's not in fact connected to sewer. A lot of the reasons for that are the change in usage. If you got 1 or 2 people in the household, they don't use much water, don't flush the toilet much. Somebody moves in with a family of 5, different usage in the septic backs up. There's significant claims, especially here, I hate to say that, soils on number 1, rocky soils, number 2, small lots with significant slope. It's hard to get septic systems to perk correctly. So a traditional system sometimes doesn't work. You have to use an aerobic system, which is 2-3 times as much money. So it's kind of a big deal. What can you do? Here's the issue. If you are an agent, remember, you're not the one investigating. You hear stories about people flushing marshmallows in the toilet and running the sewer, the street, pop up in the street. Don't do that. Unless you plug up your toilet, I've heard that story too. Too many marshmallows to plug your toilet, so don't do that. The short answer, hire somebody to do it. You can have and I don't know where our inspection guy went, but if he doesn't do it, I bet he can find somebody who can. Just confirm there is in fact a sewer connection. Don't you do it yourself, but recommend in writing to your client, hey, I'm not sure you're connected to sewer as you have told me. Why don't you follow up? Let's get this tested. Flip side, if you represent the buyer, the seller tells us we're connected to sewer. I'm not so sure. Let's get it looked at. Local markets, you're going to know. It's a brand new subdivision. You know there's a sewer there. Probably not an issue. But older houses somewhat rural, you're going to know which ones are a little bit iffy in terms of whether they're connected or not. Do the extra bit. Follow up. Tell your clients in writing. If you have it in writing, and I can use that and present it in litigation, that you advise somebody in writing to follow up and investigate. I'm going to get you out. You're going to win. It's going to be easy. If you don't have that, then we've got to jump in and fight the fight. And 2 more things about the septic stuff, and I'm sure all of you know this, but I want to make sure that the second one gets lost in the noise sometimes. Everybody knows you have to have a septic inspection done within 6 months of the close of escrow, right? Use the AEQ form, licensed inspector, la-di-da-da-da. You got to get that done. Here's the piece that a lot of agents don't really know. You have to transfer ownership of the septic system with DEQ. Oftentimes, your title company will do that for you, in fact, most of the time. But if you're working on a transaction where you know there is a septic, you deposit the septic report in escrow, everybody's signature, ready to go. Make sure with your escrow officer that they are, in fact, going to file the papers with DEQ. If they don't do that, there are fines and penalties and assessments. Most people do, but make sure you ask the question just to make sure everything is done. I's are dotted, T's are crossed.
Great, thank you for that. Great advice, Rick. Now this next question is for all of you. If a seller believes their home is haunted, is that something they need to disclose to a prospective buyer?
Wow.
I ain't afraid of no ghost. Here's my take. Can I give you the hotline answer? It depends. Is it a material fact? We must disclose known material facts. If you have a known material fact and you know the house is haunted, the law, I guess, says you have to disclose it. I'm a little bit skeptical.
And how do you prove that?
Yeah, that's.
I think you might have someone with a plaintiff that's alleging that the house is haunted may have an evidentiary problem to prove that it is haunted. But there was a case in New York in which a seller was sued for failure to disclose that the house was haunted. And the court ruled in the plaintiff's favor and said, yes, The seller was liable for failing to disclose the house was haunted, and it's a great opinion. If anyone wants to read it, send me an email, I'll give you the case. The judge was great. And the judge said that even if it wasn't a failure to disclose, that the seller breached their duty to the buyer because they were supposed to deliver the house unoccupied. I love this opinion. Now, as they say, here's the rest of the story. The rest of the story was that the seller also promoted their house as a haunted house, had written Reader's Digest articles about their haunted house. And so what do you think would happen at their haunted house? Kids, people, everybody wanted to come see the haunted house because they had promoted it. And that was really what was the basis of the judge's decision, not the quote-unquote poltergeists that were in the house, but the fact that it had been promoted as a haunted house, and that caused people and activities and kids and problems at the property. So that was a New York case involving the haunted house.
And Scott and I defended a case 10 or 15 years ago, where, 15, because you've been an AR for 10, right?
No, 7.
Anyway, the allegation was the house was haunted and possessed, and they went so far as to have a priest come out and perform an exorcism. They had a Native American do the sage, go around with it.
So it wasn't the whole house, it was a specific corner in the bedroom that they said was haunted. And correct me if I'm wrong, but I think you actually deposed Father Doug in that case, which is a fascinating transcript.
Interesting case. They went away, they ran out of money and decided they didn't have a record case after all. But it happens. I mean, once in 30 years, but it happens. What? I don't know. If I'm selling the hotel on top of the big hill in Jerome that says it's haunted, I'm staying there trying to see ghosts, and I still haven't seen a ghost. So I just don't believe it.
Well, that's interesting, so thank you all for that. Okay, Scott, this one's for you. Our members have heard about some property management companies that have gotten in trouble with the Arizona Department of Real Estate regarding their use of unlicensed assistants and unlicensed individuals. Can you share with us what property managers need to know in this regard?
Sure. I get this question from time to time. Do any of you guys read Inman News or see the headlines from time to time? A couple of you guys? Okay, so I think I get this question because there was a big flashy headline in Inman News not that long ago that said something to the effect of Arizona Department of Real Estate is forcing property management related companies out of Arizona. And that obviously drew a lot of attention because we do have some issues with unlicensed assistants working within our property management world. So I'll talk about that. First of all, if you're using unlicensed assistants, you need to make sure that you've taken a look at the substantive policy statement that the Arizona Department of Real Estate issued in 2017. If you haven't seen it, it's on their website. It's 2017.01. It's the only substantive policy statement that was issued that year, so it's pretty easy to find. But again, if you have any trouble finding it, email Michelle. Well, they all have your email. Okay, so yes, there were these two companies. The first thing the substantive policy statement does is it defines the term unlicensed assistant or unlicensed individual, exactly what you think it is. Then it goes on to list specific tasks that these unlicensed individuals can perform and tasks that they cannot perform. And these two companies were violating two of the tasks that were on that list. The first one that was on there is Commissioner Lowe is adamant about the fact that unlicensed individuals, unlicensed assistants, cannot perform tenant vacate inspections. If you want to, and you know how those happen, right? So tenant moves out, someone needs to go in, document the condition of the property, make a determination as to how much of the deposit, if any, the tenant is going to get back. Her position on that is that it has to be a licensee that is doing that. You cannot send a contractor in your place. If you want a contractor there, you can go along with the contractor, but a licensee has to be there, and you certainly can't just send your unlicensed assistant. Well, there was a Texas-based company that was named On-Site Pros, and this essentially was their entire business model. They were not real estate licensees, but real estate licensees could hire them, go in the property, they would document the condition, and they would provide estimates to the property manager or the landlord as to how much it would cost to repair the certain items that they identified. Commissioner Lowe sent a cease and desist letter, said, hey, that is the unauthorized practice of law. Rather than take all of those individuals that were performing those inspections and get them licensed, they opted to essentially stop doing business in the state. Now, they do operate in other states, but they no longer operate in Arizona. So that was the first company. The second company has to do with that portion of the substantive policy statement that says that unlicensed assistants cannot assist in the procuring of prospects for the lease or rental of real property. This has to do with marketing, right? And it has to do with advertising. We know that there's a lot of advertising regulations that are out there. And you've seen them, they're in the Arizona Administrative Code. They apply to you. They apply to real estate licensees. They do not apply to individuals that don't have a license. So Commissioner Lowe wants to make sure that to the extent that there's interaction with the public and representations being made about real property, that it's made by real estate licensees. Well, this company was a Florida-based company by the name of Virtually Incredible, and they would take lead calls and try to match people up with rental properties. The people that were on the other end of the phone calls were not licensees, primarily because they worked in a call center in the Philippines, so yeah, certainly not licensees. And that company wasn't going to get them licensed. So again, Commissioner Lowe issued a cease and desist letter for unlicensed activity, and once again, they decided to stop doing business in the state of Arizona. So you can take a couple different things away from this, but one of the things that I would say is the Arizona Department of Real Estate is out there actively enforcing these regulations, making sure that these services are being performed by licensees, which I think is good for you, but you also need to make sure that as part of your practice, if you're using unlicensed assistants, that you're using them properly and within the realm of what's permitted under the law.
Great, thank you for that, Scott. Michelle, there's been a lot of discussion about audio and video surveillance in homes that are listed for sale. What's legal and ethical when it comes to these recording devices?
Sure, there's been a lot of discussion about that. How many of you have either an audio or camera in your home or your property?
Like a Ring doorbell?
Yeah, like a Ring doorbell, right? Yeah, so about close to half of you, I do as well. How many tell your buyers when they walk in the property, assume that someone is watching or listening? Yes, I think that is great practice, regardless of whatever the law or the legal is you want to make sure that your buyers aren't saying anything positive or negative about the property while they're in there, because there's probably a good chance that the seller either is actively listening or has a recording going on in their property. So what is the law in this regard? First of all, you know that if you're talking on the phone or audio, the law is very clear. If you are a party to the conversation, you can record that conversation without the other party knowing it. That's the law. So if I am talking to Scott on the phone, I can record our conversation without telling him that I'm recording it.
You don't do that though, right?
No worries. With video surveillance, the law is that you have to let someone know that they're being videoed, that they're under video surveillance, if they're in a place where they have a reasonable expectation of privacy. In other words, you can't put a video camera in a public bathroom, right? Because when you go to the restroom, you have a reasonable expectation of privacy in there, or a dressing room, or that sort of thing. If you're out on the street, if you're out, just walking down the street, you're walking down Montezuma, down Whiskey Road, you probably don't have a reasonable expectation of privacy while you're walking down the street, right? Other people can see you. But the issue arises when you're showing a property that's listed for sale. So when you take a buyer into a seller's home to show them the property, do they have a reasonable expectation of privacy when they're viewing another person's home or in someone else's home?
Yes.
Juliana says yes. The law is unclear. It really is a gray area. We've not seen it. There's no case law that talks about whether you have a reasonable expectation of privacy when a buyer is viewing a seller's home. There is no statute that really is directly on point. So what do you do? So again, just as we started, when you're taking a buyer into a property, warn them. Just assume that you are there's video or audio surveillance in this property while you're in here, and we'll have all our discussions about the property when we get back into the car or get away from the property. So when you're representing a buyer, that's what you should do. When you're representing a seller, the safest thing for a seller to do, if they have the video surveillance, if they've got the cameras, is to post it. Post a sign. Then there's no issue. So if you just have the seller post a sign, video surveillance in progress, all you have to do is give that notice, and then your seller can be confident that they're complying with the law. But bottom line, there is no black letter law in regards to video surveillance, but it is a fact of life today. And we just need to be aware of it. And when you're representing a seller, I think it's fair to ask them to just post something to let people know that there is surveillance, video or audio surveillance in process.
And posting that sign that the property is under video surveillance, that can be a good deterrent as well for crime. But the point that I wanted to make is we have added verbiage to the cover page of the buyer advisory, specifically letting buyers know that, hey, assume that this property, any property you go into is going to be under video or audio surveillance. So when you're using the buyer advisory with your clients, that may be something worth pointing out, and it may prompt you guys to remember to issue that warning.
And one more thought, if you're frustrated with the answer, because I've had this on the hotline and people want me to give them an answer, they're a little bit irate with me that there's no good answer out there other than what Michelle just went through. This is a situation like many others in our industry right now, where technology is light years ahead of our legislature. So there is no law on the books because they haven't gotten to it. They're dealing with different issues, and technology is just taken off. And this is one of about a dozen or so issues where that's the case.
And I think there's, in all honesty, good arguments that can be made on both sides of that coin. The one is, you said you have an expectation of privacy in the home, and some people think that, why else do the sellers leave the home, right? To leave you be in there by yourself. So maybe they are supposed to be providing you with an expectation of privacy. Other people say, that's not your house, right? You're in someone else's home. You have an expectation of privacy when you're in someone else's home. So I think that there's arguments on both sides, and so it's not clear cut. And when you call the hotline, trust me, we don't want to guess at the law. We don't want to guess at what a court may or may not rule, because we simply don't know. Which is why I think Michelle's practice is a good one and the best route to follow.
Great, okay, thank you for the good advice. Rick, in a circumstance that a prospective buyer is a registered sex offender, can the seller and or listing agent refuse to sell or rent to that person?
That's a loaded question. My mic is now on.
Can you hear me now? Loaded question. The easy answer is this: sex offenders are not a protected class under the Fair Housing Act. So technically, yes, you can refuse to work with them. The flip side of that, though, is be careful. You don't need to be derogatory, nor negative, nor necessarily nasty about it. And in fact, there are, think of the code of ethics and the sort of the behavior you're supposed to engage in with everybody, regardless of criminal history or sexual offender status. You can politely say no. You can do all sorts of things to kind of soften the blow, but the short answer is there is no prohibition against refusing to work with someone who is a sex offender. You can just tell them, no thank you, number one.
And then you also have the added, I raised 2 boys, I can project my voice. You also have the issue of if the sex offender happens to be a member of a protected class. So sometimes, that can be a situation anytime that you determine that you're going to, quote unquote, discriminate against a person. If that person, even if the reason you're discriminating is because they're a sex offender, but yet they happen to fall into a protected class, you are walking on very dangerous ground, because nobody wants a fair housing complaint. A fair housing complaint, even if you are legally 100% innocent of any violation, you don't want to be dragged through that process. And the law is such that unless you can prove that the allegation of the violation of fair housing is completely frivolous, you're never going to get your attorney's fees back. You're going to have a long process. Fair housing is something that you want to be extra cautious about complying with and not violating.
I have one more point. Sure. One more point that I would make in this regard is, let's say you're listing a house for sale, okay? Do you or your seller have to disclose the presence of a registered sex offender in the neighborhood? Do you have to disclose that? No, right? You do not have to disclose it. If a buyer asks you specifically, hey, is there or are there registered sex offenders living in the neighborhood, do you have to answer the question? You have to answer it? No, you don't, right? You can say to them, that's not something we're obligated to disclose. You could refer them to the registry and instruct them to research it themselves. Now, let's say you do know, and there are registered sex offenders living in the neighborhood, and they ask you, can you say, I don't know whether there are? Can you say, no, there are not? No, right? You can't make a false statement. You don't have to answer the question, but if you do choose to answer the question, that answer has to be truthful. So that's an important point, I think, to keep in mind.
Okay, great, thank you. Scott, another property management question for you. I understand that the Protecting Tenants at Foreclosure Act is back. What does that act accomplish, and how does it affect landlords and property managers?
You guys, raise your hand if you remember the Protecting Tenants at Foreclosure Act. Yeah, a couple of you. Does anybody remember when it first went into effect? Lee, you know this one? No? So this law first went into effect in 2009. And originally it was scheduled to run through the end of 2012. But we got to the end of 2012 and the economy still wasn't doing very well, right? People were still losing their jobs, they were losing their homes. And so the act was extended. It was extended to run another 2 years, so it was extended to run through December 31st of 2014. Well, December 31st, 2014 came, and that was it. The act expired, it went away, and we didn't hear anything about it for years, for 3.5 years, until it came back last year. It came back, and it is in effect currently, and there is no expiration date that's assigned to it. So we need to have an understanding as to what the act does. Not surprisingly, it protects tenants in foreclosure, right? It's not just a catchy name, that's actually what it does. More specifically, it allows tenants to remain in a rental property following a foreclosure unless the owner, the new owner of that property, is going to move into the property as their primary residence. And even when that occurs, the new owner still has to give them 90 days. So let's walk through a couple scenarios. Property goes to trustee sale, doesn't sell, it reverts back to the bank. Can the bank evict the existing tenant? No, right? Because a bank is incapable of utilizing that property as a rental property. Let's say now it goes to trustee sale, Michelle buys it, okay? Michelle's going to utilize it as a rental property. Can she evict the tenant? No, she can't. She has to honor the remainder of the term of the lease. But if Michelle is going to move into that property as her primary residence, yeah, she can evict them, but she has to give them 90 days advance notice. So that's essentially the way the Act works. There's two other things that I think you should keep in mind when thinking about the Protecting Tenants at Foreclosure Act. The first is, it has to be a bona fide arm's length transaction in order for that lease to be enforceable. So if the borrower, the former owner, is a family member of the tenant, there's a chance that lease is not going to be enforceable. Second, the rent. The rent that the tenant is paying has to represent fair market value. So Michelle purchases that property, you go to collect the rent, and they say, here you go, Michelle, here's $5, that's how much I've been paying in rent. Well, that's not fair market value, and the court is not going to enforce that. So again, it has to be an arm's length transaction, and the rent has to represent fair market value, but otherwise the tenant is going to have rights, and you're going to take that property subject to the rights of that tenant. And you saw this, I mean, back when, in the short sale days, I mean, when this act was in place at that time, I know you saw this actually put into effect several times.
Right. And bear in mind, just a couple things, just so we're all on the same page. The foreclosing lender or the purchaser at the trustee's sale does not have to allow the tenant to stay there forever. They just have to honor the terms of the existing lease. So they have to let the lease term expire and they can take over. And here's the bigger piece where people get confused, at least in my experience. This is a foreclosure sale only. If there is a normal buyer-seller transaction, no foreclosure involved, tenants in possession are entitled to maintain possession until the lease term is over. So if somebody's going to buy a property where there's a tenant in there, make sure you tell your buyers especially, you have to wait until that tenancy expires before you can take possession and move in. Some people get confused with that. So keep those straight, please.
Yeah, I think that's an excellent point, because again, you take it subject to the rights of the tenant. Now, one thing you can do it, there's no guarantees here, but we did see banks do this to some degree, is the new owner can come in and they can try to negotiate with the tenant. They can't say, hey, I will pay you X amount of dollars if you leave the property at the end of next month and leave it in good condition. The tenant, as already indicated, is not obligated to do that, but we've certainly seen, especially with banks in the short sale days, that they would try to do that because the banks weren't in the business of being landlords. They wanted to get that property resold, and so they would try to buy out the existing tenant. So that is something that we did see.
Okay, great, thank you. Michelle, this one's for you. Last year, Arizona Realtors ran a proposition, Prop 126, that was successful in prohibiting state and local governments from enacting any new or increased taxes on services. This is obviously a huge benefit to realtors across the state, but that proposition passed by an overwhelming majority. There were rumblings about various cities challenging the new law. Where does that stand now? Do you know?
Absolutely. First of all, I have to say that I have been so honored to represent the realtors for a lot of years, and I've had a lot of proud moments in representing the realtors of Arizona. But how the realtors came together on Proposition 126 has to be one of my proudest. So in 2017, the Arizona Realtors decided to take a stand and to stop the repeated attempts by the legislature to impose professional service taxes, taxes on commissions, taxes on other services. And so once that decision was made, ratified by the board of directors in our legislative policies, we got together with the best tax attorneys that we could find, the best campaign attorneys. We ran a very successful campaign that was passed in the November 2018 election. Not surprisingly, the opposition to Proposition 126 came from the government that wanted to impose the professional services taxes for the governmental entities. That was not a big surprise. And so once the proposition was passed, various cities, including the city of Prescott, voted, their town councils, city councils. I think there was about 5 cities, again, Prescott being one of them, voted some money to retain an attorney to challenge, number one, challenge the constitutionality of Proposition 126, and also challenge the definition of services. So we continued with our tax attorneys, and I can tell you that we were 100% confident that the proposition that we backed and passed was constitutional. It was the best language that could be enacted to protect our industry and all service industries. And we still believe that today. That is the opinion of our attorneys. So we reached out to the attorneys that were representing the cities, and we let them know, we gave them the information, all the legal research that we had done. Scott did some additional legal research for us. We also said, we're happy to work with you. We understand that government needs revenue to do the things government needs to do, and we are happy. We're happy to work with you if on definitions of services is an issue. After we did that, the cities retained the attorney. Nothing else has happened. It has just gone dormant. There's not been anything introduced to the legislature to challenge 126. There's not been anything introduced in the court system to challenge 126. And there's been no demands, and actually no negotiations. They just, it's just kind of gone dormant. And I believe that it's gone dormant because I believe that the reaction right after the election was possibly a knee-jerk reaction to the passage of the legislation, because it leaves in effect any taxes that were in effect at the time, at the end of 2017. Those are untouched. And the only thing that piece of legislation, that constitutional amendment did was say that you can't raise current service taxes and you can't impose any new service taxes, but didn't impact any other revenue source for the state or municipalities. So we're really confident and remain optimistic that that issue is just going to fade away quietly.
Okay, additional question to that matter. Is there a time limitation as to how long the opposition can bring this up again?
That's a really good question, Joanna, and I don't know that there's a statute of limitations in regards to the government challenging the constitutionality. Well, it's the Constitution. It's hard to challenge the constitutionality of the Constitution. But I don't know that there's a particular statute of limitations. I don't think there is. The government doesn't like to enact laws that limit their ability to do things, and so I don't think that there is a time limit. But the fact that now we're about a year in, there's been no noise, and in fact, I emailed the attorney that represents us in this matter right before I left the office yesterday, and I said, is there any noise out there at all? And he said no, and in fact, actually the attorney that they had retained, that the cities had retained to represent them, actually moved from private practice and is now chief counsel. He's taken a government a government position, so he now is on the governor's staff. So they confirm there's nothing going on at this point.
So we're in good shape.
I think we're in really, really, really good shape, and again, so proud of what this industry accomplished and can accomplish when we all work together.
Right on. Thank you. Okay, this is our final question. As an attorney that defends agents and brokers, what are some of the more common claims that you are seeing?
How long do you have?
5 minutes.
Unlimited 2. Biggest issues, especially in the Prescott area and similar quasi-rural metropolitan areas, not Phoenix, not Tucson, but Prescott, Flagstaff, Yuma, Payson, permits are a big deal. And who's issuing the permits and whether they were issued and what's going on. Let me just run you through this scenario. Guest houses, whether they were ever permitted or not, and then they're sold as square footage, that's a problem sometimes. And then add-ons, oftentimes people do their own work. They enclose the Arizona room, they add a den, they do whatever without permits. If there are no permits for a structure and you are involved in brokering a sale, there's a decent argument that whatever sort of remedial measures need to be taken because of the lack of permits are damages that your carrier could pay. So let me tell you a couple rules of thumb, a couple things to look at. I always like to give red flags. Here's the obvious one. If the county records, the square footage in the county records don't match the square footage as measured, what's that tell you? Somebody probably did something without telling the authorities, and therefore there's an issue. So if you have, Yavapai County Assessor says 2,200 square feet, you measure it, says 2,700 square feet, that's a red flag to you. Either side, I don't care if you've got the buyer or the seller, you ought to follow up and try to figure out what happened. In fact, I've defended cases just like that, and the other side always hires a standard of care expert. That's someone who says what an agent should have done under the circumstances. And kind of the party line with all of these experts is if there is a discrepancy between the two, for a reasonable agent, that's something to give you the heads up that you need to go figure out. So tell your client, do what you can do, put it in writing. Hey, square footage is measured, does not match the assessor's office, let's figure this out. So that's one sort of red flag. The other obvious one is when you walk into a den. You can tell it used to be a little porch because the slope is pretty severe. You kind of feel like you're falling off the edge. That's an enclosed Arizona room. So those are the two with respect to the permit. The other piece, and add-ons. The other piece is guest houses. A lot of counties, a lot of cities, very, very tight on allowing guest houses. Sometimes they don't allow, for instance, cooking utensils. Cooking like an oven and a stove to be in the guest house. There's all sorts of regulations. So if you see a guest house, as a matter of course, I would recommend that you tell your buyer or sellers, let's follow up, let's make sure the guest house is permitted. Again, if it's not permitted, what's the remedy? It either has no value, you have to tear it down, or alternatively, you have to get the permits for it. Getting the permits is not just getting a city inspector out there to give you a green tag and move on with your life. Getting a permit is you tear out the drywall so they can inspect the plumbing and the electric. You dig up the footing table so they can see you actually did a footing and they can confirm that. There's a lot of work, and typically you gotta tear it apart, get the green tag and put it back together. Easy, $15, $20, $30, $50,000 to get those done. So if you see situations where you're not sure a permit was pulled, recommend that there's a follow-up. Because I've got a lot of those cases right now. And the other one, and this one I'll run through fast because this is really difficult.
Prior inspections.
I just lost my mic, and there we go. Prior inspections. I'm defending a case right now that is hot and heavy. There were 2 offers prior to this one. Both of the buyers canceled. Both of the buyers canceled for arguably structural issues. The question is how much disclosure do you make with the prior inspections? The allegation here is we did, my agent did make a disclosure, didn't get into the depth of the detail of the prior inspection reports, but the argument from the plaintiff's counsel, I've got a wonderful standard of care expert, same guy by the way, saying you should, as part of your practice, disclose all prior inspections. I don't necessarily agree with that, but make sure if you have a deal canceled because of some significant issue relating to the property condition, that your seller discloses that in some fashion. I can can run through the scenarios with you about what I think is a decent workaround, but it's becoming an issue. It's been kind of percolating for years, and I've got one case hot and heavy right now, and a couple others that's one of the additional sort of claims.
I want to just tell a quick story and go back to the permitting issue, because I talked to an agent where this happened to. So, agent was representing a buyer in Arcadia, and it was disclosed that a structure was not permitted, and the buyer was very concerned about this, and so the agent went down to the city of Scottsdale and inquired about what it would take to get the permits, gathered that information, went back, relayed that information to the buyer. Buyer was comfortable with that. Buyer went ahead and purchased it. Afterwards, buyer goes down to get the permits, can't get the permits. They weren't going to issue the permits. They were going to have to tear the structure down. Well, why? Well, it turned out the agent that went down didn't ask the right questions. Now, was that agent trying to do anything wrong? No, right? They were trying to be helpful, but the problem is they went above and beyond their scope, their area of expertise. Agents are naturally helpful people, and I think we all appreciate that. But you've got to make sure that you stay within your area of expertise. Rick will tell you the cases he defends, and the cases I defended for over a decade when I was with Rick, it wasn't because an agent intentionally did something wrong. They didn't intentionally, they didn't embezzle money. They didn't intentionally misrepresent properties. A lot of times, they try to just do too much to be too helpful, and it comes back and gets them in trouble. So make sure you stay within your scope, and if permits need to be inspected, investigated, discussed, have your client do it. Show them, give them the resources, tell them where to go, but make sure that it's not you that's actually doing it.
Yeah, that's an excellent point, and thank you. One of my cases, the agent, very helpful, went above and beyond, checked the county, went down there, no issues, no problems with any permitting, everything looks, and she sent an email that says, went down, checked permits, everything is A-OK. And come to find out the guest house has never had a permit. The county didn't have a record of it, because they're never permitted. So yeah, be careful, send your clients to do the legwork, not you. You want to work around about the inspection, so you shut up.
Go ahead.
The inspection issue, here's the story. You got competing demands. Number one, the home inspectors sometimes claim they're confidential. Number two, if you give buyer number two the inspection from buyer number one, you're going to discourage them from buying their own inspection report, and you don't want that. You want them to have an independent inspection. So I'll deal with those both in turn and quickly. Those inspection reports might be confidential, however, the contract requires that the inspection reports be given to the seller as part of the contract anyway, right? So any sort of duty of confidentiality is breached from the get-go. If you as an agent have the report and have the information, you're free to make whatever disclosure you want. If you think about it, you're not the one who had the contract with the inspector, and he's not doing anything there. So that's issue one. You may deliver that data. You may deliver the report if you want. How do you combat the second piece? If buyer number two gets inspection report from buyer number one, they're going to rely on that and not do their own homework. You don't want that. You want them to do their own thing, have their own interaction with the home inspector, so on and so forth. A workaround, I don't know if this is the best one, but a workaround is let the buyer do their own inspection. Once they've completed with that, then you may deliver buyer inspection number one to the buyer. That way they have all the data. They can cull through their inspection report, the first inspection report, and make an informed decision. The idea is to shift the risk off of your desk. You don't want to interpret buyer inspection one's report to say, okay, this is material, this is bogus, I'll disclose this, that, this. You don't want to do that, because inevitably the thing you leave out is the one that leads to the problem. That is a workaround. You might have others in your firm, but that's a solution I kind of tout people and at least encourage them to do, especially with serial cancellation of contract.
Okay, thank you. Did you have anything else to add to it?
Go ahead.
It wasn't on this. I just wanted to know where we had a question in regards to some new laws protecting military purchasing property, and I did see a little something about that yesterday with actually a realtor that's been down lobbying and working with Senator Sinema. We don't know the details of that law. But we will get that information out to you. I did just see it yesterday, and that was a question. I just didn't want to let it be ignored.
Great, thank you. All right, then that concludes our legal panel.